as we move over in studio, where the conversation on suspended ANC Secretary General Ace Magashule continues. Joining me now is our politics editor, Ngalwa, and we'll also be joined by law expert Benedict Phiri. Swu, very good morning to you. We really essentially heard Mbali speaking there about factional battles being an argument that has been put forward by Ace Magashule. And just listening into Advocate Mpho yesterday, we heard that over and over the ANC, he says, violated the Constitution in the way in which it suspended Magashule.
Obviously, Mpho, in as much as this is a legal case, it is very much political, and which is why the latter part of yesterday was about those political arguments where Advocate Mpho is in fact in line with the application or submission of ANC Secretary General Ace Magashule, portraying an ANC that is divided along ideological lines, and also portraying President Ramaphosa as someone who is using ANC processes to deal with his opponents. I think there was a strong statement that he made yesterday where he even said that, because you would recall that Ace Magashule is suspended as part initially. In fact, as part of the ANC step-aside rule. And that rule, the initial resolution was refined by the ANC. Mm-hmm. One of the things that they're bringing before court is to say that the ANC NEC does not have the powers to alter or change resolutions of conference. In fact, he went as far as saying that changing that resolution amounts to fraud and corruption, because it takes away the power of the branches. So I guess one of the things this case will have to explain, in this outcome of this case rather, will explain is whether the courts have, in fact, the NEC of the ANC has that right, because we do know that this is the highest decision-making body in between conferences, and one would imagine that naturally they would be charged with that responsibility. So whether they have the power to alter those resolutions.
Mm-hmm, mm-hmm. Let's bring into the conversation legal expert Benedict Phiri. A very good morning to you. Thank you so much for joining us on Newsroom Africa. Of course, the focus being on whether it's constitutional or unconstitutional, and the powers of the ANC NEC. What did you make of those arguments, that line of argument that we heard very strongly yesterday?
Yeah, I think, there is merit in both arguments. I think first and foremost, the question that the court will then have to ask itself is whether there has been a watering down of the resolution. I think the court will interpret and look at the substance of the resolution as it was initially proposed and what Rule 2570 looks like now, and see whether, in fact, there is substance to the allegation that the watering down has been made as a result of factional issues. And I think if it finds that, then we are in unconstitutional space, because then the motives for the Rule 2517 will definitely be subject to heightened scrutiny, and I think the court will then have a difficult time finding that it's constitutional. So those are the two layers that I think the court will have to deal with in interpreting Mr. Magashule's application. Mm-hmm. But having said that, I think obviously today we're going to hear arguments to the contrary, to say there hasn't been a watering down of the resolution, and in fact what Rule 2570 and the step-aside rule actually do is just operationalize what the ANC members had actually requested. And then obviously we'll hear around the Deputy Secretary General being properly empowered to effect the suspension on Mr. Magashule.
Now, Benedict, the argument of the Magashule's legal team is also anchored on the, they've made references to the Ramakatsa versus Magashule case. Mm-hmm. Now, that was where the Constitutional Court said that decisions of political parties are invalid if they are in conflict with the Constitution. Explain to us, just to take us through the distinction, at what point, what rights do political parties have as individual organizations with their own rules and regulations, and being voluntary parties vis-a-vis the constitution of the country?
That's actually a good pointer there, Sbu, because the Ramakatsa case is actually quite important for the right to political participation. And it doesn't necessarily distinguish between political parties having the private right to regulate their arrangement with their members through the contract of a constitution, in as much as it actually says that where you do have a contract with your members, it is a fundamental feature of the right to political participation that you meet your contract as a political party fully, right? And this is where then Mr. Magashule's case comes in, because he says, well, the contract I have with you in 2570 is that, firstly, the NEC or the NWC will direct the Secretary General, who then will satisfy himself that a suspension is in the best interest of the ANC. So if you look at that chain, firstly, there's no direction, and secondly, even if you say there's a direction, Deputy Secretary General Duarte was not satisfied that the suspension would be in the best interest of the ANC. So he's attacking that particular portion. He's saying that requirement you haven't met. And if you take Ramakatsa, you actually have to meet my contract with you to the T. You can't take shortcuts around it.
Now, Benedict, we also heard Advocate Mpho in talking about the powers of in attacking the powers of the Deputy Secretary General, talk about the fact that she is not empowered as per the Constitution, and even going far as saying that the very same Rule 25.70 states that it is the Secretary General, as in the person of the Secretary General. Isn't that a narrow interpretation of the clause?
I agree with you, Spu, that it tends to be narrow, and I think we got an inkling of where the court is likely to go with this through Judge Collipin dealing with the applications for intervention, and him speaking to the delegation provisions of the Constitution to say, the ANC Constitution, to say they must be interpreted in a business-like manner. So if you then say Rule 2570 only needs Mr. Magashule, then, it renders the whole thing unworkable, because what happens if Mr. Magashule or a Secretary General is not there? So I think we've got an inkling on where the court's thinking is going, and I think Mpho even said that the court seems to have prejudged this during his remarks.
Benedict, I'm going to ask you to hold your thoughts there. We will continue this conversation in a short while. Of course, speaking ahead of day 2 in the Johannesburg High Court as suspended ANC Secretary General puts his case forward. This discussion coming up in a short while. Stay tuned. Right, welcome back. We continue our discussion around day 2 in the Johannesburg High Court with suspended ANC Secretary General Ace Magashule, politics editor Ngalwa, joining me, as well as law expert Benedict Phiri. Benedict, let's just talk a little bit about what we heard Advocate Mpho alluding to yesterday when he said that he has the sense that the outcome of this case has already been prejudged, especially the powers of the Deputy Secretary General. Does this now signal a potential appeal, whichever way the matter may sway, according to what Mpho has already alluded to?
I think, we've got to then, before we get to the appeal stage, we've got to be in a position where the court firstly has made a decision and secondly has given its reasons for its decision. So even if the court will always go into a matter where it's read the papers with some kind of idea where the matter has to go, or the legal principles that have to be ventilated, or the facts that need to be scrutinized further. So it just so happened in this case that there was an intervention case that preceded the main proceedings. And of course, as part of that intervention case, Judge Collipin and Judge Wiener, as well as the third judge, actually had to then deal with this matter. And it doesn't necessarily mean that Ace Magashule's legal team were not heard on the matter, or were not heard adequately, or that the judges are not bringing their minds to bear properly to the matter. So I think we should actually just wait and see what happens before we assess whether an appeal is likely on that point.
Now, Benedict, let's talk about the image of the courts. Now, Ace Magashule is among a number of ANC leaders who have been critical of the courts, and I think it was in this channel where he said that the Constitution is not sacrosanct. and in another platform he said that don't worry too much about the Constitution. Now, the fact that his main argument is on the constitutionality of Rule 25.70, I'm sure that says something, or that in a way, in terms of the image of the court, what do you think that signifies? The fact that he is now asking a court to adjudicate this matter.
I think it signifies, Boo, that he actually does actually believe in the Constitution, which is really our new arrangement as South Africans. I think his legal team must also be commended, because it is a new arrangement and the foundations of it have to be tested. So we have to test what it means to have a right to political participation. We only have the Ramakatsa case right now that speaks some flesh to that particular right, and I'm glad that we have another case that will then add to the thoughts and the jurisprudence against those rights. So in as much as Mr. Magashule is saying we can pay short shrift to the Constitution, I think he also does accept that the Constitution is also quite progressive, and we should actually test its limits for our new South Africa.
Right, Benedict Phiri, thank you so much for your time and very thorough analysis. It brings us now to the court matter, which is underway, day 2. Let's take you live now to the Johannesburg High Court to listen in.